Thus, based on these facts, the defendant's motion to schedule an evidentiary hearing pursuant to Franks is denied. Defendant's motion to suppress the firearms and ammo is denied. All other omnibus issues not argued with particularity or otherwise specifically identified to the court, whether included in writing or notes or not, are denied. So anything you didn't bring up are waived.
Yeah.
You use it or you lose it. This should be a familiar phrase with anyone who watches my channel. Court administration shall settle a settlement conference, and the memorandum of court is incorporated by reference. So great.
Now, this court administration shall schedule a settlement conference. I think that's like, you pretty much got no choice. You're pretty much screwed, right? It's just like, all the evidence is in. We got all this. It's over. It's over. It's over.
Yeah.
It's over. But now, it's not. This is the conclusion. But let's get to why this action. So this is now. So now we have the conclusion. This is the conclusion. This is the probable cause. That's it. Now the judge is going to tell us why. So he's going to go through Nick's arguments.
You want me to keep reading?
I'm sorry. Defendant appeared at this omnibus hearing, charged with 3 counts. Defendant challenges the validity of the search warrant, which we all went over multiple times, and moves for a Franks hearing. Now, to get a Franks hearing, well, they'll talk about it. Defendant also challenges the seizure of firearms during the search warrant execution, which we all kept saying. Challenging the search warrant doesn't challenging the firearms for the search warrant didn't make sense, but he challenged it anyway. So, now let the judge tell him. Warrant challenges. Defendant argues that Deputy Poplin made false statements or recklessly disregarded the truth in the search warrant affidavit. Defendant points to the following in support of this contention. Now, this is Kandahokai County Health and Human Services. So I'm just going with child services for sure. I'm just saying child services, but that's what that is. Determined a report of possible child abuse did not fit the definition of abuse or neglect. M. Holt and defendant had no longer had an amicable relationship, and the defendant alleges Deputy Poplin watched defendant's YouTube video on a third-party YouTube channel. Now, those are the 3 things that Nick was challenging, right? 1, they listed out that the state said this report of child abuse didn't amount to child abuse, so he didn't tell the court that. So that's the reason why it should be thrown out. I meant the video stuff and the M. Holt stuff that he was what do you say that M. Holt was an evil person who wanted to screw Nick, and that should have been told to the judge. It wasn't told to the judge in a way that let the judge understand the nature of the relationship.
Defendant first contends Deputy Pomplin did not state in the search warrant affidavit that Child Services determined on May the 20th that the report of possible child maltreatment involving defendant's children was found by Child Services to not meet the definition of child abuse. The information provided in the search warrant case background indicates Sergeant Dave Nestor received a report regarding possible child neglect and controlled substance use. The statement was used to provide background information to explain the origin of the investigation involving defendant. There's no mention in the affidavit about any investigation by Child Services, as Child Services determination and investigation is largely separate and held to a different legal standard than that of law enforcement.
Now, hold on, stop there. I remember somebody saying that.
I think we both said that. They're different issues.
Yeah.
In different courts.
In different laws.
In different laws.
Right? So, yeah, so just because you don't have one doesn't mean
the crux of the warrant was not the allegation of child maltreatment. It simply provided the context for law enforcement to begin their investigation. And this goes to something I said on my channel before, where I said that this issue about child services is just too tangential from the principal issue. We're trying to search the house for drugs. The question that we're trying to solve in whether or not to issue the search warrant is, can we find drugs in the house? That's the thing we're trying to do.
Yeah.
So this issue relating to the child or child neglect is too tangential from that purpose, because whether it's true or not doesn't really do too much to change the calculus one way or another. So therefore, it's too tangential to be material to the issue, and therefore goes to the side, which is kind of what I said.
Exactly what you said.
The statements or lack thereof regarding child services is immaterial to the search warrant and therefore does not amount to deliberate falsehood, nor was it made with reckless disregard. In other words, no one cares.
Yeah.
Defendant next argues that Deputy Pomplin misrepresented the relationship between the defendant and Aaron. The affidavit states that Throughout Imholt's video blogs, it's apparent that they and Rekieta were friends and may have recently had a falling out. Defendant asserts that Imholt and defendant's relationship had deteriorated beyond a mere falling out, and that by failing to include disparaging statements made by Imholt on his videos, Deputy Pomplin made a material misrepresentation in the affidavit. The affidavit further explains that Imholt posted a video on May 22nd, where he speaks about defendants and insinuate controlled substance use. However, defendant Pomplin also included information that Imholt admitted to recent controlled substance use, which is essential information for the reviewing judge to determine veracity.
I'm going to get this ready.
No worries. The case background provides sufficient information to provide context of the relationship, veracity of the statements, and provides accurate information about the video. The information provided by the deputy about defendant Imholt does not amount to misrepresentation. They have, in fact, had a falling out. It accurately describes the relationship and includes information necessary to determine the veracity of the statements. Importantly, the information within the videos is not the sole basis of the search warrant, and certain statements of drug use were corroborated by Deputy Pomplin's own observation. So, like, if he was the only thing, and you attack that, then you have a problem. But of course, anyone with their salt in a search warrant probably wants to get more than one thing.
And that's what we kept saying too. It's about the totality of the circumstances. Yeah. Even if you pull that one part out, you're still good.
Right.
So it just didn't make sense. Well, it made sense to challenge the three pieces that he challenged, but it doesn't change the needle. And on top of that, like they said, it was such a small piece to it when you look at everything.
Yeah. I mean, that's like the thing. Like, all of them are relatively small pieces, and fortunately, they have multiple of them. And any one piece is, which snowflake is responsible for the avalanche. It's kind of the thing you're in at the end. And so, yeah, you have a real problem trying to attack it. And even like if you can attack the pieces, the next part of it is that has to have been basically readily observable to the signing judge at the time, that he could have made that determination based on the information that was there or not, as the case has to be readily apparent.
It's even if it's true, it's just not material. So now let's get to
and if you remove the thing, would it still issue? And if it is, meh.
Yeah,
it's like, yeah, that's absolutely right.
What do we stop at? Defendant white powder on nose?
Yeah. Defendant's final claim is the deputy did not view the original video from the YouTube channel, but rather watched the video from a third-party channel that reposted the video and did not watch the video in the entirety. The search warrant affidavit states that Eurofant, the cop, was able to view the video, was taken off defendant's YouTube and Rumble social media sites. And as we were sort of commenting between ourselves earlier, when you read this and you say taken off, the video was taken off, you can read that one of two ways, right? You can read that as that the video he reviewed, he got from YouTube, or you could also read it as taken off, as that the defendant removed it from YouTube. So that sentence is being capable of being read two different ways, which is interesting. I don't think that's deliberate. It's just an interesting syntax thing. The deputy notes the defendant appears to be drinking an alcoholic beverage, and later in the video, defendant appears to have a white powder on his nose and behavior indicative of controlled substance. The case background states that the entire video is 4 hours and 4 minutes long, and approximately 2 hours and 46 minutes into the video, defendant leaves to use the restroom. When he returns at 2 hours and 50 minutes, he appears to be making an excited look and has a white powdery substance on his nose. The Deputy Pomplin also notes that during the YouTube video, defendant has closed one eye to read the screen, ramble, and slur speech. These above timestamps described by the deputy are consistent with the video uploaded by the state. Based on the court's review of the video, the descriptions are accurate of the representation of the defendant during the video.
So essentially, the judge looked at the video with the watermark. Then he looked at the original video, looked at the timestamps, and said, these things are identical, right? These things are identical. There's no different. Now, remember when we just watched, Nick was saying, well, it's different because it said backward internet on it.
And that was the only material that mattered.
That was
different.
Yeah.
But as we're not buying it.
But as you can see, the judge is like, if they're exactly the same, it doesn't seem like it.
Yeah. It's unclear if the deputy viewed the video from defendant's YouTube channel or from a third party. And I think the reason is because that sentence is capable of being read two ways, as I pointed out. The state noted that the video from defendant's YouTube channel was disclosed to defendant on July 3rd. Even if the video defendant was a copy taken from a third party, there's no suggestion the content itself was doctored, clipped, altered, or otherwise changed. So it's digital. It's a copy. Yeah.
Yeah, that's it. And all the arguments about authentication and all that stuff, as you can see, they're out the window because this isn't a trial. When you're at trial, you have to authenticate stuff. You have to have witnesses come there.
Right.
This is not trial. This is pre-trial, and this is a search warrant. So at a search warrant, you can use hearsay, things that would never come in at trial, right?
Yeah, in a trial, you bring in the original. You get it from YouTube, and
yes. But here,
or his Rumble page, or wherever else you get it from, and call it a day.
Yeah, and you have to have it authenticated. But here, you don't have that. So let me see. The judge is a Kiwi farmer. You guys are crazy. Would we end that?
Okay, defendant also argues deputy did not watch the entire video and only watched a 1-minute clip contained in the PowerPoint, which also doesn't quite make sense because how did the clip get in the PowerPoint if not by it being clipped out by someone who watched it? But I digress.
Yeah.
The PowerPoint clip contained in the exhibit shows defendant's video is 4 hours, 4 minutes, and 4 seconds long, which is the same length. When the image is cross-referenced with the full video of Exhibit 10, the same image appears at the corresponding timestamp. Exhibit 4 is an image that's purposely taken from the clip of the PowerPoint. When the image in Exhibit 4 is cross-referenced to the full video, the same image appears. There's no evidence that the images of Exhibit 2 or 4 are an inaccurate description of the video. Most notably, the deputy asserts in the affidavit that he watched the entirety of the video that was disclosed. So you said he didn't watch it, but the deputy says he did. So...
And all the timestamps that the deputy points to are correct. All of them match up. Everything seems like he watched the video. So that it's like all the evidence that the deputy provided seems to suggest he watched the entire video. And Nick says he didn't watch the entire video. How do you know? Well, you have to. I think the court is like, we got to go with the evidence we got, which seems like he watched it.
Do you have any evidence he didn't watch the entire video?
No.
Okay. Well, the cop says he did, and you don't have any evidence to the contrary, so I'm going to go with that for the moment. Because again, remember the standard here is really, really low. Yeah. It's basically prima facie. It's prima facie, basically civil. It's kind of at least comparable. It's like he says it's true. We'll take it on its representation. He swore it under oath and affidavit, so all right. The court does acknowledge that using social media as support for a warrant is somewhat unusual, and caution must be used to ensure that an altered video, parody, etc., are not used as support for a warrant. In this case, there's no indication the deputy did not watch the video, nor is there any evidence the video is altered or parody or otherwise inaccurate. I'm not sure the degree to which that statement, though, is true, that social media content is not used in warrants, because I would think that would become increasingly true.
That we communicate over. But I'm thinking he's talking about like AI. That's the AI thing.
Right.
Like, just in case maybe AI could be. So, but here he's saying it was essentially they have Nick's original stream. They have this the stream from the other place. And they just looked at them both and said, they're exactly the same. So,
yeah. There is insufficient evidence to show the deputy made statements or omissions that were false or reckless in disregard and material. Therefore, a Frank's hearing is not required. Go away.